And a welcome back, actually, to Natasha Hausdorff. How are you today, Natasha?
Doing extremely well, thank you. It's wonderful to be with you.
Thank you. Likewise. And you're an international law expert and legal director of UK Lawyers for Israel. You're a barrister at Six Pump Court Chambers, handling commercial, regulatory, and international cases. You're also a graduate of Oxford University and former clerk to Israel's Chief Justice at the Supreme Court. Is that about right?
That's spot on. Yeah, my role is with our the UK Lawyers for Israel Charitable Trust. So it's a slight specification, but we focus on education, especially my role in terms of educating on international law. So it's wonderful to have opportunities to do things like this and get the word out.
Yes, thank you so much for joining us because I recently had a debate here in Norwegian with two of the foremost Norwegian experts on international law. I thought it was so interesting to hear different opinions on this matter, especially as it pertains to Israel and the legal status as when it comes to occupation and genocide and all of these things. So,
Mhm.
and there was actually quite a discrepancy there. So I thought it'd be interesting to hear from you on commenting on that. And for new listeners, that podcast is in Norwegian, but it's also subtitled so people can watch it on YouTube as well. I can link it in the description below here so that people can watch it and also make up their own opinion on that.
That's
But
helpful as my Norwegian is still rusty, despite
yeah, it's still
specializing
rusty.
in a beautiful country.
But we were talking about mainly three large topics, which I find very interesting, and that is the legality of the state of Israel. Where does Israel get its legal status from? And then we were speaking about San Remo Resolution, of course, which I've heard you talk about several times before. Also, you've also been on my podcast earlier where we discussed that. And let's start with that. And let's start with a bit of a meta question. Like, how is it possible to have such different views on international law itself? Is international law mostly up to individual interpretation, you think?
I wouldn't say so. And I think one of the reasons that there are such diverging opinions and, in so many respects, extreme opinions is because of the way that international law has been politicized, weaponized, abused, inverted to serve particular agendas, more so than any other area of law, of course. Part of the reason for that is that it is a lot easier to do this with international law, which necessarily has elements of the political and diplomatic woven in by virtue of the fact that it is the law that governs relationships between states. There's no major international law enforcement mechanism. We have some courts and tribunals, but we can talk about some of the serious problems with them. No, in many respects, connected to the fact that they've been taken over by many of these political agendas. So it's very unlike domestic law with police and enforcement system. That's not to say, of course, that domestic legal systems cannot themselves be, hijacked and used for purposes that, in so many respects, subvert the rule of law. And in fact, much of jurisprudential thought, the philosophy of law, is involved in trying to discern, when is law law? When does it have validity? Is there a moral element to that? Or is it only essentially, if it is promulgated through the accepted constitutional processes? Lots of people have asked, were the laws that the Nazis passed and the Nuremberg laws, were they valid as law? So this is a big jurisprudential debate, even in the domestic context. But when we look at the international realm, it's very clear to me that for decades there has been this major battle between the democracies, liberal democracies, those rule of law countries that view law as a curtailment on government power, as opposed to those despots and dictatorships that view law as a means of wielding power. And that clash between the philosophies, if you will, but also the political agendas and the tools with which these states are willing to deploy those political agendas, that's been on display for decades. You see it in the context of negotiations of international conventions. These are agreements that states sign themselves up to, so treaty law, which is one of the major sources of international law. You can see the way that certain states are trying to manipulate the development of international law through this process. But I think it's extremely important that we're clear about what's law and what isn't. What real international law says, and what is the politics, what is the inversion, what is the abuse. And I think one of the reasons people get away with, frankly, lying about what international law says so frequently, especially in the media, is that very few people have a sufficient knowledge of international law to push back on that. The general levels of literacy on international law are not extremely high. And so one of the missions, it seems, that I feel I've stepped up to in life is to try and educate as much as possible on what real international law says, and push back on that manipulation and those falsehoods. And ultimately, it is something that I believe threatens Western civilization. Looking at the trajectory of where international institutions like the United Nations, also international organizations. I know the last time I was on your show, we talked at some length about Amnesty International, because I was in Norway to debate representatives of that organization. So the trajectory of where these organizations, along with the International Legal Academy, professors, universities, academic departments, have all been driving or seeking to drive international law to, I think is extremely worrying. And it does require some very concerted effort to set the record straight.
Yes, and thank you for clearing up, especially that you work with international law to help clear it up for us laymen, because it gets sometimes it gets very technical, and you have to have really like a law degree to understand what we're talking about. So I think that is so important, because that's a term that's tossed around a lot in debates and discussions and in the news. It's international law, but a lot of us don't really know what it is and how it functions, and how it relates to each other. In how much of a sense is international law dynamic and dependent on just the relation between countries, and how much of it is more like static and fixed, and you can show to a book of rules and a book of law and say that, hey, this is correct, and it doesn't really matter what you say or what the largest, most powerful countries say. This is what the law book says. Like, and how much where's the line there between the dynamic interpretation of it, contemporary interpretation, versus the more static and law-based interpretation?
Well, it's definitely somewhere in the middle. International law is plainly dynamic. It's constantly evolving. And a big reason for that is that one of the key sources of international law, what we refer to as customary international law, is derived from state practice. It's derived from the way that states behave. So if a state is behaving in a particular way, believing itself to be bound legally to behave in that way, at some point, this rule of customary international law will crystallize, and then the state will, in fact, be bound. And this is universally applicable, except if a state is a sort of continuous objector. If their state practice demonstrates that they reject the evolution and the formation of this customary rule, then they may not, in fact, be bound by it. But that very phenomenon, which doesn't exist domestically, in the domestic context, you've got for example, in the UK, in this common law system, you've got statute legislation that is passed, and then you've got the determinations of judges in interpreting the law, common law. But that is quite a methodical, slow process, and traditionally the courts will be very slow to, develop the law in any quick or revolutionary fashion, for sure. It's all based on previous precedent. And in the international context, it's important to remember that the key players here are states themselves. And what real international law is ultimately depends on what states are going to accept themselves as being bound to. And that's why treaties, which are agreements that states sign themselves up to and bind themselves to, treaties are fundamental. And custom, the way that it evolves and then binds states, is also fundamental. Some of the secondary sources of international law that are recognized in the statute of the International Court of Justice, where it sort of sets out an authoritative selection of sources that make up recognized sources. Some of those include the writings of the most respected jurists of the age. And so this is another instance in which international law is very different from domestic law in that it can be impacted, developed, affected by the international legal academia in a way that you just wouldn't accept in a domestic context. And I think, in a sense, that's opened up this door to this kind of takeover or abuse. Because when you look at what's happened to the academy as a whole and the sort of anti-Western, anti-colonialism is being taught as a mantra, but really the means or the aim of that is to turn young people against the West. That is the ideology that is being promoted. And in the International Legal Academy, that is definitely kept in step with that anti-Western approach. But I think it's gone even further. And there has been an increasing dogma that unless you sign up to, and we've spoken at great length previously about Israel, Israel is a very prominent example of this concept of lawfare, of politics taking over international law, and this manipulation and abuse being very visible. But as I say, this is not just Israel's problem. This is a trajectory that is anti-Western, and it is in many respects a threat to Western civilization if we are not prepared to take it seriously and to hold those that are propagating it to account. So I hope that gives a little bit of color, but really happy to talk through specific examples and absolutely to pick up things from the debate that you previously had.
Yeah, so let's get into that. So the debate was between Cecilie Hellestveit, who is a Norwegian expert in international law with a PhD in it, and Ragnar Hatlem, who is a barrister, you would call in England, or a lawyer. And he has spent a lot of years really digging down into this topic and written a book on it, and is really interested in the legality and the terms of occupation and San Remo and everything. So they had a debate on my podcast about this, and let's get into the first topic is that of San Remo. Now,
Mm.
Cecilia Hellestveit, she sees San Remo and the mandate as historically important, but not as a is an historically important document, but not as a binding present-day legal title fixating Israel's borders in 2025. So she doesn't see that as an important document right now. It's important just from a historical viewpoint, while as Ragnar treats the San Remo 1920 as the central and still operative legal title for Israel and for the Jewish people, covering both sides of the Jordan and making like the later points we'll also discuss of occupation legally incoherent, because when you have San Remo there as the foundation, then that kind of nullifies the whole occupation
Mm.
um, accusations. So what do you think about these two different positions on the San Remo resolution?
That's interesting. And I find myself in the middle. I have to say that I think San Remo is important as a historical, political, and legal piece of context to the establishment of the State of Israel. It is essentially the international legal community providing the foundational basis for its backing for the creation of the State of Israel. And that cannot be ignored or simply brushed away. But for me, the far more important aspect of this is what happens at Israel's creation, what happens at Israel's declaration of independence. And I'm thinking back to a question that you posed at the beginning, I think as part of your introduction, what is Israel's right to exist? Isn't that remarkable? Isn't that
I know,
extraordinary that question is asked with respect
I
to
know.
Israel, and one doesn't ask it? I mean, when was the last time anyone queried the UK's right to exist, or Norway's for that matter? But isn't it interesting that question is posed with such frequency, and then the answer to it is some sort of indicator of reasonableness, or of course I agree with Israel's right to exist, which ultimately is often put forward in terms of I agree that Israel has a right to self-defense. This is basic stuff. I mean, talk about stating the obvious. But then why these questions are asked is instructive. I think it sheds a lot of light on the politicization of this issue that we've been discussing. But ultimately, the answer has to be you treat Israel just like any other state in the world. you hold it to the same standards, and you hold it to the relevant framework in international law. Otherwise, none of this is going to work. The system starts to fall apart. You cannot have a general rule and an exception for a country you don't like very much, or you have some political or ideological opposition to. That's not how any respectable legal system can operate. And so the question has to be, well, what is it that governs any other state's existence? And it always comes down to the moment of independence. States come into existence in different ways, but what's relevant in Israel's case is this declaration of independence in 1948 on the 14th of May. And so what we see is that there was a lot of historical, political, legal context. That is all including the Balfour Declaration, the end of the First World War, the Treaty of Versailles, the focus on self-determination of peoples, the mandate system, San Remo, the idea that the former colonial powers, although there's a big question as to whether the UK, Great Britain, would have constituted as a former colonial power at that point, given its control over the British mandate that was created. But this whole context of the fostering of peoples, including the Jewish people, significantly in what was then Mandate Palestine, that historical area, and fostering the creation of a national home for the Jewish people in this territory, that is all very much a part of that context. But then the legal questions are determined by what happens after the British withdrawal. In 1948, in accordance with the UN's blessing, if you will, under the Partition Resolution, the mandate was coming to an end, but the British withdrew. And it left a vacuum. And what emerged out of that vacuum was one state that declared independence. And there's a very good reason for that, because the Jewish Yishuv, the Jewish community pre-state, had been waiting for this moment. You will see, videos of people dancing in the streets at the news of the UN resolution, the UN vote that facilitated the British withdrawal. And that was because they had been waiting for the opportunity, the moment to declare a state. They had been building the state organizations, the institutions of a state, in particular, the Workers' Union, hugely powerful organization, still in Israel today, very, very significant political organization. You had the People's Council, you had local police services, local authorities and councils and representatives. So it was all based on that sort of, democratic mandate of people voting in their representatives. But that is ultimately the organization that then endorsed the Declaration of Independence, the representatives of the people. And those state institutions were already in existence. So the state comes into being. Now, in international law, there are recognized criteria for the existence of a state under the Montevideo Convention. There needs to be a defined territory, there needs to be a permanent population, there needs to be government and the capacity to enter into international relations. So the question you ask yourself, is a state, is ultimately, does it fulfill those criteria? And if so, is it then also recognized by other members of the international community? So in Israel's case, it declares independence in 1948, and ultimately it has many of those, well, in fact, I'd say from the moment of the Declaration of Independence, it has all of those criteria for this significant reason. And it's international law that fills in the gap here. There is a customary rule of international law, which I know we've discussed before, but it bears repeating because it is so fundamental. And it was the missing piece of the puzzle in the debate that you've just outlined. The rule of uti possidetis juris tells us what Israel's borders were on the 14th of May 1948. And so you do have defined borders under the Montevideo Convention as well. And the reason it does so is because this rule developed in customary international law all the way from the 19th century in this decolonization context in order to avoid there being a vacuum, or what the International Court of Justice referred to as the terra nullius, kind of no man's land, to avoid confusion, and ultimately by that to promote peace and stability, because you're avoiding fights over borders if there are these clear, clean lines that everyone's able to agree on. So the rule operates to say that the new state takes on the pre-existing administrative lines of whatever unit was there before. And this is critical, because when we think back to the original mandate for Palestine, it was very much bigger than what ultimately ended up becoming the State of Israel. It included what later became the Hashemite Kingdom of Jordan. At the time, it was part of the mandate that was referred to as Transjordan. But it's interesting in terms of the way the mandate was set up, what the Brits' responsibilities were towards fostering the Jewish national home in part of the mandate, and how it disapplied that responsibility when it severed Transjordan. The severance of Transjordan, though, is important because it underscores that internal administrative line that existed between what remained of the mandate and then what became the Kingdom of Jordan. And that administrative line runs all the way down along the Jordan River to the Red Sea. It's that eastern side of the triangle that so many of your viewers, I'm sure, will be familiar with on the map. That is the line in relation to all of these allegations of occupied territory that became Israel's border in 1948 automatically because of this default rule and because there was no agreement to the contrary. And that's critical because it tells us that this allegation of occupation is entirely false. It tells us that Israel has been sovereign in these areas since its declaration of independence in 1948. And what happened immediately after that declaration is that there was a war that was launched against Israel. They were seeking to annihilate the fledgling Jewish state, and Jordan occupied those areas from Israel. Now that's significant because that's where the term occupation properly applies. And when Israel recovers that territory from Jordan in 1967, in another war of attempted annihilation against Israel, when Israel recovers that territory, it's not occupying it because it's recovering its formerly sovereign territory from Jordanian occupation. And one example that I've started to refer to provide context, because as lawyers, we always look at precedents, we always look at where has this been applied elsewhere, where are there comparable situations? Well, Ukraine's borders followed uti possidetis juris. And there is a general consensus outside of Russia that Russia has occupied Crimea from Ukraine for that reason. But if Ukraine were to recover Crimea from Russia in the same way that Israel recovered East Jerusalem and Judea and Samaria, which was then under Jordanian occupation, it was renamed the West Bank. If Ukraine had recovered that territory in the same way that Israel recovered those occupied territories, no one would accuse Ukraine of occupying Crimea from Russia. And that contrast is stark. So a little bit of a longer explanation, I appreciate, but so important to say, yes, San Remo is definitely part of this, but ultimately you don't have to go further than the basic treatment of any other state in this situation. I've been discussing this application of this customary rule to Israel for over a decade, and I have yet to hear a single explanation as to why it should not or cannot apply in this case. And I've spoken to the great and good on international law on this. Many people refer back to the 1947 Partition Resolution, and this was a recommendation by the General Assembly that suggested that there should be two states created. But it was a recommendation that was never implemented, and it had no legal binding force. It's a political resolution only. And when you look at the practical realities on the ground, I think there's a very important lesson to be learned about why there were no two states that emerged in 1948. Because this concept of exclusively Arab-Palestinian national identity emerged very much later, in the 1960s, decades later. Ultimately, what existed at the time in the territory that became the State of Israel was a local Arab population. And when David Ben-Gurion declared the State of Israel, this is Israel's first prime minister, he stretched out his hand and he invited that local Arab population to build this state together with the Jewish communities. That's obviously not what happened because of the war of annihilation that was launched, but that gives you a clear indication that while the Jewish pre-state authorities existed, while the ingredients for statehood were there, and the mission and drive and determination to establish a state was there, that was not the case. And that is why there was no other state that emerged. And one of the biggest challenges I think that we have in properly understanding the legal context here is that a lot of it is being weaponized, if you will, with a rewriting of history. And the conflation of this term Palestinian and Palestine, because the geographical territory that Israel emerged from, the Mandate Palestine, is not a state of Palestine. And ultimately, the institutions in that territory were Jewish built. Visit Palestine was an initiative of the Jewish Agency. It was promoting tourism to the region. Frequently, people refer to the Palestine football team, which comprised Jewish players. This is the entity that was establishing itself in this territory amongst some Christians and Arabs in the local population. But this idea that there was a prior Arab state here is entirely false. And the idea that any entity or people, in fact, had land taken away from them is also false. So we've got the false factual situation that, the false narratives, and also then the false application of international law, which is in so many respects this perfect storm of creating this level of misinformation. But coming back to, the debate that you've described on this proper application of international law, which is universally applied and applicable to any other state emerging in these sorts of circumstances as a default rule. So whenever there is no agreement to the contrary, this tells us that the received wisdom of calling the disputed territories occupied territories, or even occupied Palestinian territories, that is entirely false. And I think that's one of the most significant issues when you're coming to assess the extremity of these opinions, because it underpins so many false allegations of illegality. Illegal occupation, illegal settlements, all of that is based on this entirely false application of the facts and the law.
Yeah, I want to get into that soon, the whole occupation thing. But I want to ask a hypothetical question first. Let's say when on the 14th of May, 1948, when they declared their
Yeah.
independence, let's say they didn't have San Remo Resolution as a backdrop, as an anchor. Could Israel still have declared internationally declared independence, or wouldn't they be able to in the same sense without the backdrop of the San Remo Resolution?
No, they would absolutely be able to. And that's my
Hmm.
point. All you need is the Declaration of Independence. That is entirely valid and it is sufficient in every
Hmm.
other context. Here, it's an additionally special case because you've got all of the international commitments that have been made at San Remo and at the United Nations, and in the context of the League of Nations, the provisions with respect to mandates were carried over under the authority of the United Nations. So this is all just additional legal, political, historical backing to the establishment of the State of Israel, which is not necessary, but it definitely, makes the case a special one in that case, and frankly irrefutable.
That's very important point, I think, because I've been thinking that that is like the most important document for Israel is the San Remo Resolution. But actually, it's not really all that necessary. It's just an important historic document, but it
Yeah,
wasn't necessary for Israel to be independent. That's very
that's
good
right.
to get that clear.
I wouldn't want to call it window dressing because that seems to
Mhm.
demean what is a very significant, international commitment. But it is very much secondary in terms of the application of international law to Israel's formation.
Mhm. So let's see here. Moving on to the topic of occupation. Now, in the debate between Cecilia Hellestveit and Ragnar Hatlam, Cecilia says that she accepts the mainstream doctrine that Gaza, the West Bank, and East Jerusalem are occupied territory in the sense of the Hague Regulations and Fourth Geneva Convention, because she says that Israel took them in 1967 from outside its recognized sovereign borders and has not fully withdrawn yet. And she points also interestingly to that Israel's own Supreme Court, sitting as High Court of Justice from the mid 1970s, explicitly applied the law of belligerent occupation and the 1907 Hague Regulations to administer territories, which presupposes that Israel itself has treated them as occupied.
Right. That's
Um,
not
how do you
correct.
respond to that? Yeah.
Yeah. So this is where clearly Cecilia and I part ways. It is absolutely not correct to say that the Supreme Court has has acted in any way to recognise or determine the status of this territory. It in fact was very careful in the judgments pertaining to lots of issues that have arisen with respect to Judea and Samaria, Israel's administered territory, to say we are applying the framework that the State of Israel has instituted since 1967 when it recovered this territory. But we are not ruling on the underlying status of the territory. And that's very important. And where it has ultimately fielded, been presented with political arguments, it has been very clear to say, this is not our role. We are simply a court that is applying the existing administrative framework. So that arises from what Israel did in 1967. And this comes to the sort of the first part of this analysis, the suggestion that Israel, obtained this territory through armed conflict. That is not correct. It recovered its prior sovereign territory. And you can see that, if you will, in respect to its conduct in Jerusalem. So Israel recovers East Jerusalem. This was a divided city under Jordanian occupation, and Jews were ethnically cleansed from the areas that Jordan occupied. But in 1967, when Israel recovers that territory, it applies its law, administration, and jurisdiction in full to East Jerusalem. And it says this is the unification of the city. It's never to be divided again. And Abba Eban, the foreign minister at the time, writes to the UN Secretary General, and he says explicitly, this is not annexation. And I think that's very important, because you annex another sovereign's territory. You annex territory that is not your own. But this is not annexation, because Israel is recovering its former sovereign territory. You cannot annex your own sovereign territory. That's what it did with respect to Jerusalem. But with respect to the rest of Judea and Samaria, or as Jordan had sought to rename it, the West Bank, Israel didn't apply its law, administration, and jurisdiction in full. Now think about the context in which Israel has recovered this territory. It is just, in a sense, defeated Jordan. Israel has, from the outset, from that Declaration of Independence, sought peace with its neighbors. And at the time, and some people still operate under this mantra, at the time there was a real sense of land for peace. If Israel gives up land, its neighbors will give it peace. That's been relatively unsuccessful, especially as far as the Palestinian Arabs are concerned, unfortunately, but that was the philosophy. And so from the Israeli perspective, if you anticipate that peace with Jordan will be achieved by giving Jordan some of this territory, some of the West Bank or Judea and Samaria, then you're not going to apply your law, administration, and jurisdiction in full in the same way that you're applying it in full to East Jerusalem, which is non-negotiable. Israel is not giving up again those holy sites, because it's only under Israeli sovereignty that people of every faith have had access to those sites. So that's the starting point. And instead, therefore, of applying its law, administration, and jurisdiction in full to its underlying sovereign territory, Israel applies this administrative framework, a temporary administrative framework, which ultimately lasted until the Oslo Accords in the 1990s, fine-tuned it, retweaked it, and created a slightly different framework. But the intention was that it was temporary until peace with Jordan was reached. That came along in 1994. And the Jordanians didn't want anything to do with the territory. So land for peace sort of fell apart a little bit. But that temporary administrative framework is what Israel has applied certain aspects of the laws of occupation in, to assist it administering a territory and a people that were not its citizens. So that's, if you will, an unusual state of affairs, but much about Israel's history is sui generis, is completely unprecedented and unusual. And this is what happened. And you can see in terms of the way that it has approached the local populations in these two respective places, in East Jerusalem and in Judea and Samaria. In East Jerusalem, Israel gave residency to these local Arab inhabitants, and they have the option to apply for citizenship. Israel didn't impose citizenship on them, and I have to say that there has been a great deal of pressure within these communities not to apply for Israeli citizenship over the decades since then. That is changing. And many, many more applications, in fact, especially since the 7th of October, many more applications for citizenship have been made by those residents of East Jerusalem. But in Judea and Samaria, it's very important to be clear when we're looking at these Supreme Court decisions. And I appreciate, for the vast majority of international lawyers, they'll be in translation. There are many examples of the court being asked to grapple, with the legal status of outposts, settlements, and the unfortunate consequence of this temporary administrative framework, is that there is a real mishmash of law in these areas. You have Ottoman law, which regulates a lot of the land property situation. You've got Jordanian law, British mandate law from before that, elements of Israeli administrative law on top, and then the framework of these rules of occupation that Israel has introduced. So it is a fiendishly complex part of the world to sort of determine legal issues, and the Supreme Court has been tasked with that on numerous occasions, and it is applying all of these different layers and frameworks in that context, but it has categorically not changed or determined in any way the status of that territory. And when we come back to the original status on the 14th of May 1948, I think it's just important to recognise and be clear that this is the default position. It can be changed at any time with an agreement to the contrary. It's simply the case that we have not yet had an agreement from 1948 until 2025 that has changed the status of that territory. And the massive change in administrative framework that was instituted by the Oslo Accords, which created the Palestinian Authority and gave the PA autonomy in the West Bank in areas A and B, that was very clear that it was a provisional arrangement, that these were interim accords, and that there would be a final status negotiated settlement that would address the question of borders, as well as a few other major sticking points. But that question of borders has ultimately never been addressed and never been changed from the original starting point.
But how would you, how can we explain such a discrepancy in interpretation of the international law? Because both you and Cecilia Hellestveit, you're both experts in international law with lots of experience, many years of experience, and it's so fascinating to me that we can have such discrepancy in this topic. How do you find that? How do you understand that? And would you say that this is about what we were discussing earlier about how one sees international law? Is it about intertemporal view of international law versus contemporary view? How do you find this?
It's a very good question and a very fair question. And I, like Cecilia, we did a panel together. I think she's a wonderful person. Clearly, we have very significant disagreements on this. And from my perspective, again, I go back to the comparison with other situations, the application of international law without agenda. Now, I'm not suggesting that Cecilia is coming at this with an agenda, but unfortunately, international organizations and international institutions are. And I know that she references the International Court of Justice, advisory opinions on this, and UN resolutions. They're not binding. And they are as valuable, because they're not binding, as the legal analysis that goes into them. And frankly, the analysis that has gone into them on these issues is utterly woeful. Part of that, unfortunately, is a reflection of the makeup of these institutions. So, for example, throughout much of the period in which the International Court of Justice was dealing with these very, very controversial issues with respect to Israel, it was headed up by Judge Salem, who was previously Lebanon's ambassador to the United Nations, a tremendous track record of anti-Israel sentiment, extreme anti-Israel sentiment in his speeches to the UN, and he left the court in order to become the Lebanese prime minister. So talk about, politics infiltrating and affecting law and the proper application of law. And that is a real shortcoming of many of these legal institutions, or supposedly legal institutions, the fact that judges are appointed by countries. I don't think, despots and dictators will be appointing judges on the basis that they think they will be, objective arbiters of matters of the rule of law. No, the countries that view law as a means of wielding power will be appointing judges to these courts and tribunals that they think will protect and pursue their own political agendas. So I am inherently perhaps somewhat more skeptical of these international courts and tribunals and international organizations as a result. But fundamentally, I do not accept that this received wisdom that has erupted with respect to the way that these laws are allegedly being applied to Israel is acceptable. And I really think that rather than saying, "Oh, the UN says so," which is for the most part not a legal body, it's purely political, or human rights organizations say so, you have to drill down to the why. And if people are not able to articulate the why, and you would not believe the number of responses I have had in these discussions, with the greater good of international law that tell me it just is. That's just not good enough. There needs to be an analysis and explanation and, a reflection of practices in other countries. Another big comparison here is how, where else, occupied territory is referred to. And in particular, this allegation, this label that is applied to the disputed territories in Israel, this label of illegal occupation. It's not actually used anywhere else. Yes, there are situations of occupation that exist around the world. They don't get the same kind of attention that territories in and around Israel receive. And there's also a very, very significant disconnect between situations of real settlement activity that are accompanied by very serious human rights abuses around the world that receive absolutely no attention, and then the allegations that are made against Israel that are false, not just on the basis of the international law applicable to the status of the territory, but also to the international law under the Fourth Geneva Convention that many people refer to when they make the argument that settlements are illegal. There are major, major flaws in the proper application of law in this context. And you look at other places where there are, real settlement activities that fall under the provisions that they seek to apply to Israel, and it's simply not talked about in terms of illegal settlements or the transfer of civilians in Nagorno-Karabakh, in Cambodia and Vietnam, in northern Cyprus, in many, many situations with respect to Ukraine, Georgia, in Abkhazia, many, many situations that are simply ignored by the international community. And there we kind of, I think, can pull out another thread, which is to do with this international consensus. And that ties into the academy and the response that anyone in the academic world receives when they call out this received wisdom. Cecilia is I'm sure, I know, unfortunately, seeing as the backlash that she seemed to receive after we did a panel together, is experienced in the appalling abuse that is meted out to individuals who do not toe the line, who have not drunk the Kool-Aid on this. And that's scary. And I see it as a real duty to call that out and to stand up for the proper application of international law on these issues. But this takeover, especially through organizations which had once such respected reputations for upholding international law, for fighting human rights abuses, that are now key proponents of regimes, ultimately, that are the worst human rights violators in the world. I mean, that world has turned topsy-turvy. And it takes very, very brave individuals in the world of academia to stand up against it.
Because how much would you say that the UN is indispensable when it comes to interpreting and dealing with international law? Is it on the one hand just another huge NGO that is larger than necessary, and on the other hand, could we just dispense with them and look away from them and interpret international law without them? How much is the UN an important part of the picture, and how much do we actually need them to understand international law?
Yeah, so the UN doesn't interpret international law. Ultimately, the statement that come out of the UN or UN organizations, they are political, and I know a lot of the time they purport to say X, Y, Z about international law. So and so is violating international law, but I mean they're not authoritative, and frankly, they fundamentally get things wrong a lot of the time, and that's unfortunately reflective of the makeup of this institution. It is not democratic, and it is not made up of countries generally that respect rule of law. The vast majority are, questionable in their approach to the law, and you see that across so many. I mean, UN Watch has done phenomenal work in pointing out how utterly ridiculous the resolutions being passed at the UN Human Rights Council are. And when Saudi Arabia is appointed to the presidency of organizations or committees looking into women's rights around the world, I mean, it is beyond farcical. And so, because of that, no, these institutions simply don't have the kind of validity that many people are encouraged to believe that they do. And I remember, gosh, coming up to 2 years ago now, I suppose, I was in Toronto in a monk debate, debating Mehdi Hassan on many of these issues. Not that he knows anything about international law, but his fallback position was this: is the UN wrong then? Is the ICJ wrong then? Amnesty International, human rights wrong? They're all wrong then, are they? And the answer is yes. And they're all wrong for the same reason. And actually, I discussed this at some length when I was last in Norway, because I was being asked to engage with international organizations there, and Amnesty International in particular. There were a number of debates that were set up on my trip, on my tour. When you look at the position that these organizations have taken in essentially parroting Hamas propaganda, and that's clear from the methodology section. If you look at what the report says, it makes it clear that in the Amnesty International report accusing Israel of genocide, they don't have people on the ground in Gaza. They rely on local government authorities, Hamas. So these so-called human rights organizations take Hamas propaganda, they stick into a document which has their header, on it. That gets recycled into UN resolutions or the UN Commission of Inquiry, which simply parroted that report and declared that Israel was committing genocide, or it gets cycled up into opinions by the International Court of Justice. And then these so-called human rights organizations point to what the ICJ has said and say, see, the ICJ says so, on the basis of the false information that they put into a report. And that ultimately, I mean, it's a rotten system. It's a disgustingly rotten system, which, many people discount and say, oh, well, it's all international politics and we don't really have to pay attention. Wake up would be my message to them, because this infiltrates, this poison infiltrates into domestic settings. And it's not sufficient to say it can be ignored because it's all international politics. And there will be very real repercussions, I'm sure, for the state of our way of life, essentially, which is being threatened by this, our way of life in Western liberal democracies. So I think that's really important. And to recognize the shortcomings of these organizations, they are not gospel. And because they have been put on this pedestal for so long, we see a situation in which the hijacking of them, frankly, I think was inevitable. Because if you have this stamp of authority, if you are a UN organization that is ultimately, if you're UNRWA, complicit in not just the 7th of October atrocities, but the entire system of Palestinian terrorism, because they teach kindergarten kids from tiny ages that the highest calling in life is to become a martyr and to be able to participate in terror activity, and then they facilitate that by allowing the use of their facilities in Gaza by Hamas and Palestinian Islamic Jihad, and that they perpetuate this diabolical situation for Palestinian civilians, that they are abused continually and used by terror organizations, and that then has UN, the UN stamp of approval. It's an appalling state of affairs, and increasingly, I think that is shattering with the reality of the consequences. of bestowing this sort of holy status on these institutions that have been completely taken over.
Yeah, these NGOs, they're almost like closed loop, like
Yeah.
self-referencing systems. Because I had these whistleblowers, Danielle Haas from Human Rights Watch and Dr.
Right.
Yariv Mohar from the Israeli chapter of Amnesty International, which was actually closed down, suspended, because they had a difference of opinion on the report saying that, concluding that Israel was committing genocide in Gaza, and they said no, we don't agree to that, and they, of course, it got suspended. So that says all you need to know about these organizations. So, and the fact that that is like a closed loop system together with the UN, and that's there's something corrupt in there, there's something rotten in there, but that gives you this whole, it's such a high threshold, especially in Norway and a lot of Western countries, to say that all of these NGOs, all these organizations, they have they're not trustworthy on this topic, and that gives you so much um, resistance. That's such a steep incline to be able to say that, and a lot of people would just back up and say you're crazy. And who are you to say that against all these beautiful large organizations? And it's such a steep incline. How would you respond to that? And um, how does one argue that case that all of these organizations have their own agenda and are not trustworthy anymore?
On the specifics, which is what I did with respect to the Amnesty International report. I mean, the methodology section was the explanation, if you will, for why all of this false information was in there. But so many of these canards have been completely debunked. UK Lawyers for Israel has put out briefings and analysis, both of the famine canards. I mean, that's another modern blood libel, that Israel was creating a famine in Gaza, and the way that you debunk these falsehoods on the specifics is on the basis of open source material, right? On the famine issue, the Israeli army unit that is responsible for providing humanitarian resources to the local civilian population, COGAT, they have a website where they've just published the volume of aid going into Gaza. And they actually have oversight of everything that's gone in, because they have to check it to make sure that Hamas are not smuggling arms and explosives into the Gaza Strip, that this is actually legitimate aid. It gets checked and it gets facilitated in. That's all publicly available information. On the casualty figures, right, we've also put out detailed analysis of the false casualty figures that Hamas have been parroting, which are also parroted by the International Court of Justice, by the Commission of Inquiry, by these so-called human rights organizations. They are inflated figures. They do not account for any distinction between civilians and combatants. And on the basis of, again, publicly available information, the analysis of their own stats, which are internally inconsistent, that have been called out by other data scientists and statisticians. I mean, all of this has, in fact, been grappled with. The kicker here is that the media doesn't cover any of it, because it's not sexy and it doesn't sell newspapers or headlines on broadcast media, and it doesn't fit within the received wisdom. And that's ultimately the key issue that needs to be broken through. And I do think it's possible, because I think if people fundamentally understand, A, they have been lied to, they are having the wool pulled over their eyes, but also that this is not just something that's in the Middle East and that they can ignore, that actually, these practices being used against Israel are coming for them next, then I think there is scope to wake up to these issues. But one of the key problems is that, first of all, forgive me, the media isn't covering the analysis, the specifics that have been debunked in each of these reports. But it's also a problem that necessarily the detail with which you debunk this false information is much less interesting, especially in the kind of TikTok era. And it's a lot easier to get away with these, grandiose false statements than to debunk them on the basis of people having the attention span to listen to the specifics. And you add into that mix the fact that these false, grandiose statements are falling on the most fertile ground of the oldest hatred in the world, the hatred of the Jews. And all of these blood libels, these modern blood libels of occupation, ethnic cleansing, colonialism, apartheid, famine, genocide, violations of international humanitarian law, all of these are very much harder to address and debunk, because once they see that, the average individual, once he sees that, or once he sees, photographs of allegedly starving Palestinian children, he's told that Israel is responsible for this. He doesn't wait, or he's no longer interested in the story that then debunks each and every single one of those photos and says, actually, this is a child with serious underlying health defects, deficient, birth issues, or underlying diseases, which has meant that they haven't been able to intake food. Nothing to do with the availability of food in the Gaza Strip. And plus, you can see that if you look at the very well-fed mother next to the child. I mean, all of this, unfortunately, and I'm sure there's beautifully reasonable psychological analysis that underpins it. It's very, very difficult to get through with the facts once this sensationalist, false, grandiose statements against Israel have been have gotten out there.
We're moving towards the end there, but just a last question before we hang up here is that I recently had the executive director of Amnesty International Norway here on my podcast, and I challenged him on the new report that they've come out with. Finally, like 2 years plus after October 7th, they came out with a report on October 7th, and I challenged him, like, why did you come out with a report so early on what's happening in Gaza, and concluding even before the International Court of Justice that is a genocide? And on the opposite, like, they came out with this report now on October 7th, and they're saying that is not a genocide. How could you say that Gaza is a genocide, while as what Hamas did on October 7th is not a genocide? And how do you reconcile those two things?
Well, I'd be very interested in what their answer was, but I see it as, pure political agenda, I'm afraid. They have become a mouthpiece for Hamas. It was clear in the methodology of their report, and it takes a real. I'm sorry, I don't think I can put it in another way. It takes a real sickness to be able to publicize and give your good name to that kind of false material on the one hand, while seeking to paper over the realities. Genocide has as its core an intent to eradicate an ethnic, racial, religious, or national group, in whole or in part. As such, you are targeting the group because of who they are and seeking to wipe this group off the face of the earth. That is what the Nazis did with respect to the Jews. That is what is at the core of Hamas's agenda. Everybody knows it. And if Amnesty were in any doubt, they had GoPro videos of Hamas footage where they were celebrating doing exactly that on the 7th of October. It's beyond any comprehension that reasonable people can involve themselves in ultimately supporting forces that are so dark, that are so dangerous, that are so barbaric and genocidal and medieval in their approach to those genocidal acts. And it is one of the great mysteries that I have. So if the representative was able to shed any particular light on it, I'd be very enthusiastic to hear it. But so many of these so-called human rights organizations have followed in this path that I think it just becomes that received wisdom within those circles. And if you call it out, my goodness, will you be in trouble?
Yeah, I didn't really get a proper answer from him. I didn't really understand his answer. I think he said, like, yeah, it reaches up to the levels of perhaps crimes against humanity, but it's not at the threshold of genocide. That's and I didn't really understand and comprehend his answer. But people can look it up. But anyway, we're moving towards the end here, and I want to say, Natasha, thank you so much for joining us on the podcast here and enlightening us and educating us on all the complexities of this stuff, and sharing your thoughts on it. Thank you so much.
Thank you. Always a pleasure to speak with you, and wishing you and all of your viewers a very happy new year.
Thank you. Likewise.